are faced with a constitutional crisis. Of course, that's what I wanted to address, or want to address tonight. And that is the crisis facing us, its origin and its rectification. So 1 moment ago, the gentleman that mentioned term limits. In 1995, there was a case that reached the Supreme Court out of Arkansas. 23 states had proposed term limits, 2 in the Senate, 2 terms in the Senate, and 3 in the House. The Supreme Court overturned, said you can't do that. No constitutional basis for that. Justice Thomas had a good line, I thought. He said, where the Constitution is silent, it acts as no bar to the will of the people or the states. Brennan wrote the majority opinion, and one of the arguments used by Brennan was the 10th Amendment. He said that the 10th Amendment indeed reserves certain powers to the states that have not been delegated. However, he said since the activation, the institution of the Constitution, no states have employed term limits, therefore the states have lost the right. And it is shifted to the federal government. Of course, that's wholly without constitutional basis. Certainly in Article 1, we have the qualifications for representatives and we have qualifications for senators, but the qualification clause in no way obviates the states from instituting term limits if they wish. Again, delighted to be with you, and I hope that you find the presentation meaningful and helpful. Philadelphia, 1787. Representatives from the 13 states gathered there on May the 28th of that year. They arrived in Philadelphia for a specific purpose, and that was to make the Articles of Confederation more exigent to meet the needs of the nation. Obviously, the Articles of Confederation had failed in a number of respects. And so they were there for the purpose of amending, of bettering it, if you will. But instead, they prepared a constitution which would meet the demands of the new nation, broken now from England, and established a new government, a new order, and a constitution that would meet the needs and demands of the new nation for all of time. It has served us well for 225 years. 55 men attended at one time or another. We are told Forrest McDonald of the University of Alabama said of those who were gathered there, taken as a whole, they were as brilliant an assembly of statesmen as ever met in America, and perhaps in the world. I read interestingly the other day that when Dr. Franklin died, he had some 5,000 volumes in his library. They were men. One of the men read 8 hours a day. 8 hours a day, in addition to other duties that he performed. They were indeed a bright lot. Their work was completed on September the 17th of that same year. 39 of them signed the completed document. And as you know, it was ratified by 9 states, July or June 21, 1788. New Hampshire was the 9th state. The 9th state, there were 13 as you know, the 9th state constituted the 3/4 that was needed to ratify and to put into activity or to effectuate the new Constitution. John Adams of Massachusetts, a signer of the Constitution, or of the Declaration rather, and the second President of the United States declared the Constitutional Convention of 1787 to be the greatest single effort, he said, of national deliberation that the world has ever seen. William Gladstone, the great British statesman, spoke of the United States Constitution as the most wonderful work ever struck off at a given time by the brain, he said, and the purpose of man. Matthew Spalding of the Heritage Foundation said the creation of the United States Constitution is a seminal event in the history of human liberty. Paul Johnson, the English historian, said the creation of the United States of America is the greatest of all human adventures. No other national story holds such tremendous lessons for the American people themselves and for the rest of mankind. This great Republican experiment is still the first, best hope for the human race and will not disappoint an expectant humanity. We as a people, as a nation, now find ourselves faced with a constitutional crisis which threatens the vitality and, yes, the continuation of this republic as founded and as ordered. Sanford Levinson of the University of Houston School of Law, or Texas rather, School of Law, said the death of constitutionalism may be the central event of our time. Our Constitution, the covenant, and the governing document which has served as a major instrument for the development and the advance of the greatest nation on earth. One establishing the rule of law, one establishing justice, one marking out the areas of power of each of the three branches, that they be restrained and kept within those borders established, that they exercise only those powers that have been delegated by the people of the states to them. As well, it is a constitution established to protect the rights and the liberties, not only of the people, but of the states. And let us not forget that it was the states, we the people of the states, who formed this Constitution and ratified it. It is we the people of the states who formed this new government, the federal government. The states then are not in submission to the federal government. Today, they think of themselves as being the master and the states mere provinces. That is a total misunderstanding of the United States Constitution as founded. There is a particular body of people, men and women, who have given themselves to dismantle not only the Constitution, but the governmental order of its founding. And that body of men and women is none other than those who Mr. Hamilton said in the Federalist Papers would be the guardians of the Constitution. That is, they would have as one of their primary responsibilities to look carefully at whatever the exec does, whatever Congress does, and if there's some question of an act, of a piece of legislation by either of these, that once it reaches the Supreme Court, then the court itself would look to see if the powers exercised were within the borders granted and within the powers enumerated. In this way, they would act as guardians of the Constitution, keeping each of the respective branches within the borders of their assigned powers. The question is, who keeps the federal judiciary within its borders? It has broken through the fence, and it is out there doing whatever it chooses in the name of the Constitution, as we shall see. It has brought us to a point of crisis that, again, calls into question whether or not this republic will survive. Thomas Jefferson foresaw the danger to our republic from this quarter, from the judiciary. Mr. Hamilton said in Federalist 78 that it is the least dangerous to the rights and liberties of the people. The rights and liberties of the people, he said, could never be endangered from this quarter. And yet, our rights and liberties have been, and are endangered from this quarter. The United States Supreme Court has absolutely no authority to create rights, neither does it have authority to deny us those rights given to us by God and protected by the Constitution of the United States. Mr. Jefferson, very prophetic he was, he said this: about the Supreme Court. The germ of dissolution of our federal government is in the Constitution of the federal judiciary. An irresponsible body working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction, until all shall be usurped from the states, and the judges as the ultimate arbiters of all constitutional questions. And it would place us, he said, under the despotism of an oligarchy or the rule of the few. He closed by saying, the Constitution has erected no such tribunal. William Brennan became a justice on the Supreme Court in 1956. And he said, we are the final word on the Constitution. Mr. Brennan is quite incorrect. According to the Constitution, and according to Mr. Jefferson, according to Mr. Madison, and according to any and everything I have read about the Constitution of the United States. Also, Charles Evan Hughes, who was a justice on the Supreme Court from 1910 to 1916. Justice Hughes said, we are under a Constitution, but the Constitution, he said, is what the judges say it is. But Article 6 of the Constitution of the United States says that only those laws made pursuant to the Constitution shall be deemed the supreme law of the land. If the Constitution is disobeyed by the Supreme Court, the highest tribunal in this nation, if it enacts law, if it makes a decision having no root in the Constitution, we, the people and the states, are under absolutely no obligation to obey that law. As we shall see in a few moments, the Constitution, or rather the Supreme Court, increasingly is handing down decisions having absolutely no root, no connection whatsoever with the Constitution of the United States. And thus, a crisis has been introduced. To understand the foundation of this crisis, we must go back in time, way back in time to the 1870s, to a man by the name of Christopher Columbus Langdell. He started off all right, perhaps, with his name, Christopher Columbus, but Mr. Langdell was smitten by Charles Darwin's theory of evolution. And he applied that theory of evolution to law. That law would be evolving. Well, the Constitution, as you know, has fixity. The Constitution can only be changed according to Article 5. Either by, what, 2/3 of each house, the Senate, and the reps, and then sent to the states, and it must be ratified by 3/4, or by a convention called for by the states and approved by the Senate and the House. That's the only two ways you can change it. But under Langdell's theory, the Constitution loses its fixity, and in essence the Constitution becomes whatever the court wants it to become. It was used to establish what he called the case law method. Now attorneys in the law schools no longer study the Constitution. You can graduate from most of our law schools, I have read, and never studied the Constitution of the United States. Pat Robertson graduated from Yale Law and said he did not read the Constitution until after he graduated. What are they reading? What are they studying? The case law, the decisions of the Supreme Court of the United States. And so law is evolving now. It evolves by the decisions made by the justices. Whether they're rooted in the Constitution or not is of absolutely no concern. They just simply study the decisions. And so out of these decisions, new principles are established, a new foundation is established for deciding law.